Hi, welcome to another Tips for Landlords and Property Managers video brought to you by FastEvictLawGroup.com. Today, we'll go over important information landlords must know about small claims court for COVID-19 rental debt. Please remember, the contents of this video shouldn't be considered legal advice. What is considered COVID-19 rental debt? The first thing we'll cover is under what circumstances non-payment of rent is considered COVID-19 rental debt. A tenant cannot be evicted for non-payment of rent under the following scenarios. If your tenant failed to pay rent from March 1st, 2020 through August 31st, 2020, and your tenant submitted a declaration of COVID-19 related hardship. Keep in mind that a declaration can be submitted retroactively and only one declaration is required for the entire period. If your tenant failed to pay rent from September 1st, 2020 through September 30th, 2021, and your tenant submitted a monthly declaration of COVID-19 related hardship. These protections expired on September 30th, 2021. As of October 1st, 2021, a tenant cannot be evicted for non-payment of rent in the following scenario. If your tenant paid at least 25% of the rent from September 1st, 2020 through September 30th, 2021, and has paid rent in full as of October 1st, 2021 onwards. If your tenant has avoided eviction up to this point, they still must pay the rent they owe during the pandemic. This is what is called COVID-19 rental debt. This debt is considered consumer debt and a tenant cannot be evicted for this debt. California Rental Assistance. The California Rental Assistance Program states that qualifying households will have 100% of their unpaid rent covered for up to 18 months. Both the landlord and the tenant may start the application. An application can be submitted even if your tenant has since moved out and assistance for up to 12 months of utility bills is available. When can you file for small claims? A landlord may sue their tenant in small claims court for COVID-19 rental debt as of November 1st, 2021 if the tenant fails to apply or does not qualify for rental assistance, has not or isn't willing to pay COVID-19 rental debt. The $10,000 limit a landlord can sue their tenant for has temporarily been lifted. Before winning your case. Before a landlord wins judgment in small claims court for COVID-19 rental debt, the landlord must be able to show proof that they in good faith investigated if their tenant qualified for rental assistance, show proof that they cooperated in their tenant's efforts to obtain government assistance, or show proof that they themselves applied on behalf of the tenant. Is there anything else? There are additional California-wide protections that apply to COVID-19 rental debt, such as landlord cannot charge late fees on rent owed from March 1st, 2020 through September 30th, 2021. Landlords cannot apply security deposits to rental debt payment unless written permission is obtained from the tenant. COVID-19 rental debt cannot be sold or assigned in certain situations. Step 1. Filing your case. Before filing your case, it's important to be aware that there are new forms to consider that have specific COVID-19 rental debt verbiage. You can contact our office for help to get started. There are two types of cases you can file: small claims complaint versus a civil complaint. In either case, the landlord must account for the rental debt owed. The landlord must provide evidence of the investigations, cooperations, or application for rental assistance on behalf of the tenant. What is the difference between a small claims complaint versus a civil complaint? A small claims complaint is typically quick and informal. There is no discovery process, the need to find evidence. The tenant doesn't have to respond to the complaint. Both parties must represent themselves, although consulting an attorney before your case is allowed. It's important for you as a landlord to understand that you shouldn't forcibly remove your tenant by either changing the locks on your property or removing their items. Even if the judgment is in your favor, COVID-19 rental debt is no grounds for eviction. Your tenant may use this harassment as defense in court. Step 2. Tenant response. As mentioned above, if the tenant is sued in small claims, they do not need to file a response. If they are sued via civil complaint, they have 30 days to respond. Step 3. Preparing for the hearing. Your main goal in court is to prove that the COVID-19 rental debt amount you are suing for is accurate and that you cooperated in the efforts to obtain government rental assistance for your tenant. Bring any evidence to your court hearing that will help your case. Once your evidence packet is organized and complete, make sure you make 3 copies. Step 4. Hearing date. Don't forget to bring your copies of the evidence. Show up on time and dress sharp. Be prepared to be at court for about 4 hours. Once your case is called, the plaintiff typically presents first. Be prepared to answer any questions the judge may have and refer to your evidence packet when necessary. Important note, the judge will most likely ask what it would take to settle before proceeding through the rest of the hearing. Step 5. Post-hearing. The judge typically won't make their decision at the hearing. Both parties will receive the judge's decision via mail. If the judge rules in favor of the landlord, the tenant will be ordered to pay the landlord the awarded amount. The landlord must wait at least 30 days before enforcing the judgment. If the judge rules in favor of the tenant, no money is owed to the landlord. The landlord is not able to appeal or file any further actions for this case. A small claims judgment is valid for 10 years and can be renewed. If a tenant does not pay the ordered amount or misses payments, the landlord can proceed to ask the court to garnish wages or impose levies on bank accounts until the debt is satisfied. Thank you for watching. Please contact our office if you have any questions about the small claims process for COVID-19 rental debt. Please like, share, and subscribe if you have found this video useful. We'll see you on the next one.